The Verdict, a Sidebar production, hosted by Kent Myers and Mick Cornett. As a part of its traditional and continuing commitment to public and community service, Crow & Dunlevy sponsors The Verdict. Also sponsored by Delta Dental, Oklahoma Lawyers for Children, and C.H. Guernsey & Company. Each week on The Verdict, we present an objective discussion of contemporary and legal issues, topical issues that will affect Oklahomans in their daily lives. The Verdict, a Sidebar production.
And welcome to this special edition of The Verdict. Glad you're with us. I'm Mick Cornett, and as you regular viewers know, I am joined as always by one of Oklahoma's top legal experts, Kent Myers.
A very special evening indeed on a Monday night. This isn't Rawhide, this is The Verdict. And thanks to KSBI for letting us come on during this time period and present to you what you really have requested. And that is to bring back to The Verdict two participants who have been on before but did not come on head to head. And we're going to be talking about the subject of the dramatic increase in the insurance premiums for medical malpractice insurance in Oklahoma and elsewhere, and what causes it. We'll try to find out. We're going to have a few rules we follow. Each participant will be able to give a short opening statement. Then Mick and I will ask questions of each participant, pretty much alternating between our guests. And then each guest will have a chance to ask the other one a question, and then you'll hear final closing statements. This is not a 30-minute show, it's an hour show, we're pleased to say, and we've got plenty of information to pack into it. I'd like to start out by introducing our two guests. Across the table from me is the president of the Oklahoma Trial Lawyers Association, Jim Loftis. Jim is a Southeast Oklahoma State University graduate and a University of Oklahoma graduate. He is a lawyer that practices law in Norman, and his practice focuses in part on medical negligence cases, and speaks tonight on behalf of the Oklahoma Trial Lawyers Association. Jim, welcome back to The Verdict.
Thank you, Kent.
We're glad to have you.
I'm glad to be back.
To my right is Dr. Jack Beller. Dr. Beller is president-elect of the Oklahoma State Medical Association. Dr. Beller was educated at Oklahoma State University and the University of Oklahoma. He also is a resident and practices in Norman. He is an orthopedic surgeon in Norman. And Dr. Beller, we welcome you back to The Verdict for another appearance.
Well, thank you for asking us.
We'll start with 2-minute opening statements, and Dr. Beller, you'll go first.
Thank you. About 2 years ago, the physicians at the Oklahoma State Medical Association noticed what was happening around the country with the medical liability system that was out of control to the point that it was driving doctors out of the practice of medicine. We saw such things as in Pennsylvania, 1,000 doctors have left the state or retired early because they couldn't get or couldn't afford the medical liability insurance. We saw pregnant ladies in Mississippi who now have to drive 100 miles each way for their pre-medical care because their local doctors can't get or can't afford their medical liability insurance. The only top-level trauma center in the state of Nevada had to close for a while last year for the same reason, leaving thousands of patients without the care that they needed. We didn't want that to happen in Oklahoma. We put together a task force of many groups of medical providers. We looked at what was happening in those states that were not under crisis and found out that the common thread in all of those was that their legislature had already passed meaningful medical liability reform. We took those tried and true issues, we put them together into a package and presented it to our state legislature to give them the opportunity to proactively prevent the crisis from occurring in Oklahoma, rather than having to react to it after it was already established as it had in the other states. It is those issues which we have presented to our legislature which we are here tonight to discuss, and we thank you for the opportunity.
Mr. Loftis?
Thank you. Well, fortunately, we don't live in Pennsylvania, Florida, Nevada, or Mississippi. We live here in Oklahoma, where Oklahomans are fair-minded and conservative folks who listen to both sides of an issue. In Oklahoma, physicians such as Dr. Beller enjoy the lowest medical malpractice premiums in the entire country, and we don't have caps in Oklahoma. We trust our friends and our neighbors to decide what's fair in a medical negligence case, just like we trust them to say what's fair in a criminal case where life and death decisions apply. We've heard that doctors are fleeing. They're not fleeing Oklahoma. The truth of the matter is, doctors in states that don't have caps, such as Oklahoma, there is a higher pro rata share of doctors in those states to treat patients, just as it is in Oklahoma. We believe that juries are made up of people that are our friends and neighbors, and Dr. Beller's friends and neighbors as well. And they are the folks at the local level who should make this decision, not an insurance industry and politicians in Oklahoma City or Washington, D.C. who determine what's fair for an innocent victim.
Mr. Loftis, thank you. You're watching a special edition of The Verdict. We're in a debate format tonight. We're trying to answer the question, who or what is responsible for the increase in medical malpractice insurance premiums? We'll be right back. Welcome back to this special edition of The Verdict, a debate concerning the increase in medical malpractice insurance premiums. Who or what is responsible? Our guests are Jim Loftis and Dr. Jack Beller, and time for some questions and answers. Kent?
Dr. Beller, let me start with you. There seems to be little doubt that at least in the last couple of years, medical malpractice insurance premiums have increased dramatically for physicians here in Oklahoma. It seems to me there could be a number of causes of that, perhaps jury verdicts in favor of patients, settlements that doctors have entered into voluntarily in advance of going to trial, but nevertheless required insurance payouts, or perhaps the insurance companies are simply overcharging the doctors because they think they've got a captive a group that can pay the bill. What do you see as the reason for this dramatic increase?
Well, here in Oklahoma, we find ourselves about a year or two behind those states which are in acute crisis. And what we've found here in Oklahoma is that over the last 2 years, the awards and settlements have actually gone through the roof. Over the 10-year time period from 1991 to the year 2000, the average payout of judgments and settlements in the state of Oklahoma was about $18 million a year. For the years 2001 and 2002, that reached up to the high levels of an average of $33 million a year, a huge increase from an average of 18 to an average of 33. Our medical liability insurance premiums are based on losses. And so this year, the physicians in Oklahoma have received an increase in their medical liability premium of 60% over what they paid in 2002. And that's based entirely on the losses that our insurance company had to pay out over the last 2 years.
Well, I would probably take issue with at least a couple of Dr. Beller's characterizations. First of all, the losses that have been sustained by PLICO, the Physicians Liability Insurance Company, relate not only to the payouts they have, but they have to use reinsurance, and the reinsurance market has doubled and tripled. Even PLICO's own website admits that. PLICO has had to pay, when they used to pay $8 million, now they pay $14 million in reinsurance costs, and those costs aren't associated with anything that goes on in Oklahoma. Further, to say things have gone through the roof implies that patients have received some unjustified award. If there has been an increase in awards, you can look at the increased cost of hospitalization, physician's fees, the cost of prescription drugs, and I think that's what you can attribute those to.
Jim, let me ask you a question about that subject of the jury verdicts going through the roof. Are the average size of jury awards increasing? Are we seeing runaway juries in Oklahoma awarding enormous verdicts that have no relationship to the amount of harm done?
Well, I don't want to sound cavalier with my answer, but if we're having runaway jury awards, they've run so far away that none of us can find the name of one. We've heard about that and heard about it and heard about it, but yet we don't hear Dr. Beller or anybody from the insurance industry giving us the name of one person in one case that got an award that they claim was not merited by the facts of the case. Furthermore, as we know, in Oklahoma, we have a three-tiered protection system. If, in fact, a jury was influenced by passion or prejudice, we have the protection at the trial court level that the judge can set aside that verdict. We have protection at the Court of Appeals where they can likewise do the same, and we have protection at the Supreme Court where they can also set aside any verdict that is not grounded in the evidence that was presented to the jury.
Dr. Beller?
The awards and the settlements have gone tremendously much higher over the last few years in Oklahoma, just as the numbers that I gave you. I'd also like to show you the national numbers. From 85 through 97 on the national basis, we had this level of awards. For the years from 97 to 2001, as I've said, Oklahoma's about 2 years behind them. You can see the slope that has increased, so that earlier, the average award was in about the 400 to 500,000 range. At this point, it is over $1 million as the average award nationwide, and it is getting there in Oklahoma as well.
Dr. Beller, some have said that this is really an artificial crisis, that insurance companies simply made bad investments and are trying to recoup their losses, or that the expenses incurred by 9/11 have caused the insurance companies hardship and they're trying to increase the premiums on doctors to try to get some of their money back. Are any of those possible causes, do you think?
Well, let me explain about Oklahoma. As Mr. Loftis mentioned, in Oklahoma, our medical liability insurance is called PLICO. We have a unique situation in Oklahoma. Our medical association owns our medical liability insurance company. It is a non-profit company. The premiums that our insurance company assesses on our physicians are based on one thing and one thing only, and that is on the payouts from the previous year. And as you can see, our payouts have jumped tremendously in the last 2 years, and that's what's resulted in our insurance company raising our premiums 60% this year. Also uniquely in Oklahoma, we do not have one single dollar invested in the stock market. So you can't say that our premiums have gone up because of bad investments. We don't have those investments. Our return on the investments have stayed constant over the last 5 to 6 years.
Well, while Dr. Beller points out that PLICO does not invest in the stock market, PLICO does buy bonds. As we all know, the last 2 to 3 years, bond interest rates have dropped from maybe 8-9% to maybe 4 or 5%. So PLICO has seen a loss in the income that they derive from their investments. Furthermore, PLICO does not write the entire amount of insurance that they issue to their physicians. They have to reinsure it through an international reinsurer. Anything over, I think, $400,000 of PLICO's insurance is passed on to a reinsurer, and they do invest in the market, and their rates to PLICO have gone up from $8 million to $14 million, which is a 60-70% increase.
Mr. Loftis, thank you. You're watching a special edition of The Verdict. We're discussing medical malpractice insurance premiums and why they're so high. We'll continue when we get back. Since we're ending that third question with Mr. Loftis talking, how are we? Mick Cornett, Kent Myers, and guests back on a special edition of The Verdict. This telecast is running in multiple time slots, but typically you'll see us here on Sunday mornings at 9 o'clock discussing legal and political issues pertinent to Oklahoma. But in this telecast, we are hosting a special debate to try and answer the question, why has there been such dramatic increases in the premiums for medical malpractice insurance? Our guests are Dr. Jack Beller, the president-elect of the Oklahoma State Medical Association, and Jim Loftis, the president of the Oklahoma Trial Lawyers Association. And the debate continues. I have a question for you, Mr. Loftis. And the question deals with a Daily Oklahoman analysis of some court records. It says if only 6% of the medical malpractice claims go to jury trial to begin with, and then 79% of those are found in favor of the defendant, how can those numbers skew the system and cause such an effect on the premiums?
Well, I think the short answer to that is it can't and it doesn't. Premiums in Oklahoma are tied to the reinsurance costs that PLICO incurs when it has to go outside to these international reinsurers to pass off the majority of the insurance that they write for their physicians. The cost of litigation in Oklahoma is not a primary factor in the increase in premiums that the physicians are seeing this year. It relates to the reinsurance costs.
Dr. Beller?
There are three folds to that answer, and I'm going to try to get them all in 30 seconds. One is that it doesn't take a whole lot of multi-million-dollar judgments by a jury to scare the insurance company into settling many more that might go to the jury and have multi-million-dollar settlements. The second issue is that fully 2/3 of all the cases that are filed are dismissed before they ever get to trial, and they have to be defended. It costs an average of $66,000 to defend 70% of the cases that never get to the jury, and those are monies that the patients never see. The third is about the reinsurance. What Mr. Loftis is not familiar with is that the reinsurance for PLICO is under PLICO's control. It again is not invested a single dollar in the stock market, and it is controlled by the T-bill rate and is constant for the last 5 years.
Let me ask you, Mr. Loftis, a question. I'm quoting from a representative of the Medical Association. It says, far from being the protectors of patients from incompetent physicians, attorneys actually are the benefactors by keeping over 50% of jury awards in medical liability cases. How can that be under our Oklahoma system?
It cannot be that way under our Oklahoma system. Any lawyer that was guilty of doing that would be and should be disbarred. I don't know where that information is coming from, but I can tell you it is absolutely inaccurate and untrue.
Dr. Beller?
When a award is given, we know that the patients receive about 20% of that award for their actual injuries. They receive about 25% of that award based on their non-economic pain and suffering injuries. The legal system takes about 55% of that. The plaintiff's attorney can keep up to 50%. The defense attorney can keep whatever it costs for him, and there are court costs. So our patients end up with only about 45%.
Dr. Beller, let me ask a follow-up question relating to attorney's fees. The proposed legislation that's now kind of on hold in the Oklahoma legislature would include a limit on the attorney's contingent fees that would be proper. What kind of a limit is being proposed in this legislation, and why do we need it?
As the statistics that I just gave you indicate, the patients are not the ones who benefit most from the medical liability system we have right now. The legal system does. We think that if there is a patient who has an injury, and there are patients who have injuries, we stand fully behind the concept that they should be able to recover those costs. We are proposing that the attorneys can keep 40% of the first $50,000 judgment. They can keep 33 1/3% of the second $50,000. They can keep 25% of the amount between $100,000 and $500,000, and they can keep 15% of the amount over $500,000 judgment. That gives them about $136,000 on a $500,000 judgment. We think that that's fair, that the patients should end up with the majority of the settlement.
Well, I think when you hear that at first blush, it sounds like that this proposal is designed to benefit the patients. But the reality of it is, medical malpractice cases cost $50,000 to $100,000 routinely to put on, and that's money that the lawyer has to invest. The patients, they typically don't have that kind of money to invest in their own case, so the lawyer has to put that money at risk. And whenever you start capping what a patient can contract or a client can contract with a lawyer, if you start putting limits, artificial limits on that, what you're doing is essentially closing the door to the courthouse to many of the patients, because they're not going to be able to find competent lawyers willing to undertake their case and take the risk not only of their 500 to 1,000 hours of time on a case, but $50,000 to $100,000 of their own money. So while it may sound good, in a practical sense, it is actually designed to keep patients from being able to prosecute their claims against negligent physicians.
Dr. Beller, let me ask you another question. There's been a recent Harvard University study that looked at the correlation between the amount of jury award and the actual harm done to the plaintiff, and seems to suggest that there isn't a real correlation between the two, and that the award may be out of proportion in relation to the harm imposed. Are you familiar with that, and do you have any thoughts about that?
Yes, I am familiar, and you can look that study up on the hhs.gov website of the Health and Human Services. What they found was that there is absolutely no correlation between the amount of money awarded by a jury and the presence or absence of negligence. What they did find that there was a direct correlation between the amount of money awarded and the amount of disability that a patient might have, regardless of who caused that disability. So the physician and his insurance company were then paying for a disability that they did not create.
Well, we've heard about Pennsylvania, Mississippi, Nevada, and now I guess we've moved on to Harvard, but the bottom line is we haven't heard anything about here in Oklahoma what our juries do. We know we have a three-tiered protection system starting with the trial judge. We haven't heard any cries for the ouster of the judiciary that they're not doing their job as the gatekeepers. If in fact there is no evidence to support a finding that a physician was negligent, the trial judge, the Court of Appeals, and the Supreme Court are all three obligated to vacate that verdict and write an opinion that says, look, there was no evidence to support this. We reverse and remand and enter judgment in favor of the physician.
All right, Mr. Loftis, thank you. Well, I mentioned earlier that this show is being videotaped and actually airing in multiple time slots. If you're watching us on Monday night, then I want you to stay tuned after this commercial break, and we'll have more of the debate. If you're watching us on a Sunday morning, then you'll be able to see part 2 of this debate next week at the same time. In either case, we appreciate you watching The Verdict. We'll be right back. Mick Cornett and Kent Myers on this special edition of The Verdict. This show is in a debate format. We're discussing the issue of the rising costs of premiums for medical malpractice insurance. Kent?
Yes, for those of you that are just joining us, depending on when you tuned in, what we're talking about in a debate format is why is it that the medical malpractice insurance premiums in Oklahoma for Oklahoma physicians have risen so dramatically? What are the causes? And what can, if anything, be done about it? What should be done about it? I want to very briefly reintroduce our guests to you. Across the table from me is Jim Loftis, the president of the Oklahoma Trial Lawyers Association. And to my right is Dr. Jack Beller, the president-elect of the Oklahoma State Medical Association. Mick?
Well, there's some proposed legislation, the Medical Association proposal, that would cap $250,000 cap on non-economic damages. Is that necessary?
Absolutely not, unless the goal is to discriminate against the groups of people in Oklahoma who can least afford discrimination: children, the elderly, and stay-at-home parents. If an arbitrary $250,000 cap is put in place, the insurance industry will have absolutely no incentive to resolve even the most meritorious of those cases, because they will know that the only thing they really have at risk is $250,000.
Dr. Beller?
Let me reiterate something that I've said earlier, that our number one premise is that we are not proposing limiting any patients' ability to recoup their actual losses. We're only asking for a reasonable $250,000 limit on the non-economic losses. And I would be insulted if I were a stay-at-home mom and it was insinuated that my duties had no economic value. There are economists who testify all the time about the economic value of stay-at-home mothers, about the future earnings of even a child. So those are smoke and mirrors that are trying to cloud the issue, that we are trying not to limit the actual damages, only to put a reasonable limit on the non-economic, non-quantifiable damages.
Dr. Beller, continuing on the topic of the proposed legislation, there is another provision which I understand would require something that is a little different than what we now have in Oklahoma, and that is certification from an expert before a medical liability case could even be filed. In other words, I suppose the expert would have to look at the thing and say, yeah, this is worthy of being filed. How would that work, by the way, and why is that necessary?
The reason it's necessary is that we know that fully 2/3 to 70% of all of the cases that are filed are dismissed with no settlement and no judgment before they ever reach trial. Those are the type of suits that are frivolous, and as President Bush has categorized them, junk lawsuits, but they are expensive. It costs a lot of money to prepare the defense for those. That is money that is paid into the system that no patient will ever see. What we are asking simply is that before an attorney files a suit, he simply goes to a physician and says, would you review this? Would you give me an opinion that yes, there was some deviation from the standard of care? We think that that would go a long way towards eliminating those frivolous junk lawsuits so that the system doesn't have to waste that money and it can go to the patients who really need it.
Well, I don't believe that simply, one, I don't know what the percentages are, but two, I don't believe that you can say simply because a lawsuit is dismissed for whatever reason, we don't know why those were dismissed, some of them were settled. But in any event, I don't believe that you can say that they're junk lawsuits just on that basis. However, I can tell you that I have never filed a medical malpractice case without first having consulted with a physician. I personally don't see that there's a great deal of, that Dr. Beller and I would be at issue on this. If in fact, I've not seen the legislation, but if in fact it did have some provision where if someone comes in the day before their statute of limitations runs, that you're not precluded from going ahead and filing that and being given some adequate amount of time to investigate the case, but yet be able to protect the patient's rights as far as their potential claim. So this may be the one issue that Dr. Beller and I have some agreement on, subject to the proper wording of the language of the proposal.
All right. We're going to get to a short break. You're watching The Verdict. We're discussing medical malpractice insurance premiums and why they're so high. We'll be right back. Glad you're with us for this special edition of The Verdict. We're having a debate concerning the rising costs of premiums for medical malpractice insurance. Who is to blame? I'm Mick Cornett along with Kent Myers, and our format will change slightly in this section, but first we want to have a question. Kent will be tossing one out here that both of them will have a chance to respond to.
Yes, Dr. Beller, ask you first, and then of course Mr. Loftis will have a chance to respond, but the phrase defensive medicine has come up and has been the subject of a good bit of debate. Defensive medicine generally is defined as being medical services performed on patients by doctors or tests, procedures, in order to protect the doctor from later being sued and the claim being they didn't do enough, they should have done more, they should have run additional tests. And that cost is running in the neighborhood of $50–60 billion a year in the United States. Some may say, well, one reason these premiums are getting so high and one reason health costs are getting so high is that doctors are practicing defensive medicine. Do you think it's happening? And if it is happening, is it justified?
I would say that there's no doubt that that is happening. The defensive medicine costs are $60 billion a year annually. The reason is that we have become such a lawsuit-prone society that we sue first and ask questions later, that the physicians in our country and in this state have learned by touching that hot stove once too often that we have to do things to defend ourselves before we are even charged. So we will order tests and order consultations that we can use in case we do get sued for whatever reason, frivolous or not. So yes, it does happen, and yes, it is driving up the cost of medicine, and it's been estimated that at least half of that $60 billion could be saved with medical liability reform.
Well, I don't know where the $60 billion number came from. I suspect it came from the insurance industry, quite frankly. And I would just remind our viewers that anyone who deals with a health insurance company, whether it be a HMO or PPO, I don't know if theirs are a lot better than mine, but I can't even get them to approve the tests that I need to have done, much less some defensive medicine tests. So I think that that is a tempest in a teapot. The numbers are created, and I do not believe that there's a great deal of defensive medicine being practiced. But in the event there is defensive medicine being practiced to some extent, how can you say that it's bad when you run an extra test to make sure that you're not missing something on one of your patients?
We're going to change the format just slightly here and give each of our guests a chance to ask each other a question. Mr. Loftis, why don't you go first and address your question to Dr. Beller?
Dr. Beller, I want to forget for a moment about economic losses, and I want to focus my question on the non-economic damages that you've discussed. And I would just like for you to answer for me, sir. Being put in a wheelchair for the rest of your life, as I understand it, would be a non-economic damage. Do you believe that being placed in a wheelchair for 40, 50, 60 years, that non-economic damage is only worth $250,000?
The major premise we work under is that we think that our patients should be able to recover all of the damages that they suffer, all of those quantifiable damages. Being put in a wheelchair isn't economic damage. Most of the damages that are quantifiable are able to be defended and shown to the jury. So we fully support the ability of a patient to recover all of those economic damages which he or she might suffer. We're just asking that a reasonable limit be placed on the non-economic damages, and that's all we're asking for.
Dr. Beller, your chance to ask Mr. Loftis a question.
Yes, one of the issues that is causing the increase in the medical liability insurance premium has to do with a law in Oklahoma that's called joint and several. And my question is, why would the trial lawyers be against an issue of fairness in which, as the way things stand right now, if a defendant is judged to be as small as 1% responsible for the damages, that he can be held 100% responsible to pay for the judgment? Why is that not an unfair issue when 35 states in this country have already changed that law?
Well, Dr. Beller, I can't speak for the basis for the legislation as it was put in years and years ago, but I can tell you why I think it is. The law, as I understand it, looks to compensate the innocent victim. And in every medical malpractice case, the victim is blame-free. They have had nothing to do with whatever malpractice has been visited upon them. The law looks at that and says, as between the innocent victim, who had no fault in this matter whatsoever, and the 2 or 3 or 4 physicians who are out there, if those physicians caused or contributed to that injury, then we should have a situation like you want, where the patient gets fairly compensated, regardless if you've got an irresponsible physician who doesn't carry any insurance. If the other physician who plays a role in that does carry that insurance, the law says it's only fair that this innocent victim be fairly compensated. And if it all has to come from one physician for that victim's compensation, then the law says that's fair.
We're going to go to a break and come back with the final segment. We're discussing medical malpractice insurance premiums and why they're increasing and why they've gotten so high. You're watching The Verdict. Welcome back to this special edition of The Verdict, a debate concerning the rising cost of premiums for medical malpractice insurance. I'm Mick Cornett. Kent Myers is my co-host. Our guests today are Jim Loftis, the president of the Oklahoma Trial Lawyers Association, and Dr. Jack Beller, the president-elect of the Oklahoma Medical Association. Kent, what do we do next?
Let's close it up in the sense that let's give each participant an opportunity, unencumbered by questions or responses, to just say what's on their mind. Let them have a little closing argument, if you will, and we will start with Jim Loftis.
Thank you, Kent. Today we've heard examples about crises in Nevada and Mississippi and Pennsylvania and Harvard studies, but the bottom line is we've not heard anything about any medical malpractice litigation crisis in Oklahoma that the insurance industry and the physicians can put a name or a face to. The truth of the matter is Dr. Beller may be, and his physician friends may be seeing an increase in their medical malpractice premiums, but it's just like you and I have seen an increase in our homeowners' premiums, probably doubling over the last couple of years, and it has to do with the investments that the insurance companies have made in the market, whether it be stocks or bonds. As Dr. Beller pointed out, they invested T-bills. Well, as we all remember, T-bills used to pay 6, 7, 8%. Now they're about 2%. That cuts into the insurance company's income, and then they come looking to us, just like they look to Dr. Beller, to make the money back through increasing in premiums. The $250,000 cap that is proposed is unfair. The insurance industry is using scare tactics that doctors will be fleeing the state. Well, they're not fleeing Oklahoma because they had the lowest malpractice insurance premiums in the entire country, even after the increases that they're seeing this year, like we are in our own insurance. There are no runaway juries in Oklahoma. Juries in Oklahoma are conservative. They're made up of our friends and neighbors and Dr. Beller's friends and neighbors. They listen to both sides of an issue and then they make a decision. Those decisions are apparently fair because we've not heard the name of one innocent victim that Dr. Beller or the insurance industry can say, look at this victim, they got too much compensation. Their case was such that the evidence didn't support the physician or the hospital was negligent, and the doctor shouldn't have been found negligent in that case. We believe that it is better to let local people decide local issues rather than trust the politicians and the insurance industry to come up with a one-size-fits-all arbitrary cap of $250,000 that discriminates most against children, the elderly, and stay-at-home parents, those people who can least afford the discrimination. Whenever you start to think about who do you trust to determine what's fair, just think if you would rather trust your friends and neighbors or the politicians in Oklahoma City or Washington to figure out what's fair in the event you or one of your loved ones was sitting before a jury and wanting to determine what would be fair for your family.
Dr. Beller?
Thank you. I would like to say thank you to Mick, Kent, KSBI, and the sponsors of this program for permitting us to come here and talk about an issue that is of critical importance to everyone who might have to visit a doctor's office, go to an emergency room, be admitted to a hospital, or have a loved one in a nursing home. When we saw this crisis headed to Oklahoma, and I will tell you it is here, we are already seeing family practice doctors in rural Oklahoma who will no longer deliver babies. We are seeing doctors who have 15 or 20 years left in their practice, who are in their 50s or retiring early because they can't tolerate this medical liability system that is in Oklahoma and in crisis. We have other doctors who are surgeons who say, I'm going to quit doing surgery. They're not going to be available when you go to the emergency room and need that care. We put together a coalition of healthcare providers to propose to our state legislature a system of bills that would stabilize this medical liability insurance situation. We look to the states that have had this in place. These are the states that have stable systems. California's had theirs in existence for 28 years. It has worked. We are proposing issues that you have heard us discuss tonight, which are not experiments. They are tried and true. We've talked with our legislature. We've asked them to pass these. We know that these gentlemen and ladies out at the state capitol are the only ones who have not only the opportunity, but the responsibility to prevent this crisis from affecting the people who elect them. We need your help. We're asking that tomorrow you call your senator, you call your representative, and you call Governor Henry and tell these upstanding elected officials what it would mean to you if the obstetrician wasn't there when your baby needed to be delivered. If the neurosurgeon wasn't available when your teenage son was knocked unconscious in a football game or your wife had a head injury in an automobile accident. Explain to them what it would mean if you lost the access to the medical care that you have now, that we have seen happen around the country in a crisis state, and it's getting here in Oklahoma today as we speak. Explain to these gentlemen and ladies at the state capitol that this is not about the cost of being a doctor in Oklahoma. This is about the cost of being a patient in Oklahoma. Are you, as a patient, going to have to pay more for your medical care? Is your employer going to have to pay more for your insurance premium? And are you going to have to pay the ultimate price of not having access to care when you need it? Our elected officials are upstanding and have the best interest of the state of Oklahoma in mind. They need your input on what it would mean to you if you lost that care. Thank you.
Dr. Beller, Mr. Loftis, we appreciate you both coming out.
Thank you.
I'm sure our audience is further enlightened on the subject. Thanks again.
Thanks, guys.
Kent and I'll be back with a final comment after this. Welcome back to The Verdict. I want to thank you for joining us. Today's show was a debate on the medical malpractice insurance premiums and why they are so high.
And what to do about it. Governor Henry, who has been on our show now a couple of times since he's been governor, has formed a task force chaired by Andy Coates, the dean of the law school at the University of Oklahoma. And the task force includes representatives of the medical profession, representatives of the Trial Lawyers Association, representatives of lawyers groups that defend doctors, and healthcare providers of other kinds. And they are charged with, as the governor told us in his recent appearance, they're charged with the responsibility of making some recommendations to the governor and the legislature about what ought to happen with this proposed legislation, capping non-economic damages, requiring a pre-suit certification, limiting the amount of contingent fee that can be charged by a lawyer in a medical malpractice case. These are proposals that will be addressed by this task force, and We don't know, of course, what the legislature will do.
But it's scheduled for this session. I mean, there could very well be a vote.
Well, I think it will be definitely this session. The governor, I think, has given the task force the charge to finish quickly. Don't let the session close without giving us a report, and we'll hear a lot more about it.
Well, we'd like our viewers to tell us what they think on the issue. Maybe they learned something in this debate that has led them to a conclusion of some sort. And you can go to our website and participate in a poll on this subject. The website address is www.theverdict.tv. I think if you just follow the instructions at that point, you'll be able to see what you need to do to help us in this poll. And also, if you have any ideas for a future show topic, we'd love to hear from you. Kent, final comments?
Well, a matter of personal privilege and a sad one. As many of you know, I recently suffered the loss of one of my daughters, and I wanted to take this minute to thank everybody that's responded. And I really do appreciate, as does all the members of the family, all the kind messages and thoughts, and it's just genuinely appreciated.
And Kent and I'll be back next week with another edition of The Verdict. Hope to see you then. So long.